Rose, thank you very much, and good afternoon, everybody, and welcome to today's webinar. And we certainly, again, appreciate your patience as we work through some technology challenges this morning, but all good. My name is Craig Vaughn. I'm the president of Castle. Castle specializes in providing management services to apartments, condos, and HOAs in Florida. We partner with approximately 300 associations through 7 offices and about 1,750 teammates right now. Welcome. I want to welcome you to our webinar this afternoon. This has certainly been an interesting time. The landscape is changing hourly almost, it seems, and we're going to have Gary comment a little bit about that shortly. Thank you for your leadership. Thank you for your thirst for information. We have more than 100 participants this afternoon. We've received a bunch of great questions that we will take you through. Having reviewed your questions, most are covered in the material Gary and I will be presenting. You're welcome to continue to ask questions through the Q&A feature of this webinar. I will attempt to work those questions in to our discussion. Please note, if you see me looking strangely around, up and down, I am reading your questions, and that's what I'm trying to sort out. The platform we're using this afternoon is Zoom. We checked the Zoom platform before we got on. There are some issues with Zoom, so if you have a particular challenge during this webinar, I would just encourage you to log on and log back in again, and hopefully everything will be fine. Before I ask Gary to introduce himself, I want to remind everyone that he's not intending to provide specific legal advice for your association. We'll identify some issues for specific questions you have. We would ask you to reach out directly with your legal professional and other professionals. Gary, if I can you introduce yourself and talk a little bit about your firm?
Yes, thank you. Can you hear me well, Craig?
Excellent.
Excellent. Okay, thank you. And I want to thank Castle for putting this webinar on. It's a pleasure to be able to participate. I thank you for the invitation. Craig, you're a great partner in this, so hopefully some people will be educated a little bit through this process. But yeah, my name is Gary Moores. I'm a partner with the law firm of Siegfried Rivera. We provide full service community association representation, principally in the Dade, Broward, and Palm Beach markets. You know, we are very engaged right now in all matters COVID, which I know is challenging for everybody. As a general comment, I just want to start off by letting everybody know that, you know, this is, as I know most people understand, this is fairly uncharted territories where we look towards other areas of history to kind of bring us to where we're at right now. But the reality is we are, going through this and foresting these woods right now, and good teamwork is very important. So, obviously the managers, the lawyers, to an extent CPAs, some of our service providers that each association is working with, they all should be called in to assist through these moments. I'm looking forward to the interchange with Craig this morning and this afternoon, and hopefully we can enlighten some people with some good information. But thank you, Craig.
Great, Gary. Thank you very much. I just wanted to quickly review with everybody what we're going to talk about today, the main kind of headings. We're going to go through the current regulatory environment, talk about emergency powers of the board, talk a lot about reopening amenities and a specific framework around how we recommend that getting done, talk about meetings, and then what's next. And if we have time at the end of the webinar, we'll get to some specific questions. If there are questions asked that, are not specifically answered, and that you've chatted them in, we will circle back to you after the webinar today to answer that. So Gary, let's jump in. Seems everyone is issuing executive orders. We have the president, the governor, the county, the municipal level. I would suggest it's a minefield out there when it comes to regulations. We are still under the state of emergency order issued by the governor. Can you give us an overview of the current regulatory environment, starting at the state level and then zeroing down today on Palm Beach, Broward, and Miami-Dade?
Right. I mean, it's a great question, and it's probably one of the more difficult realities of what we're dealing with. So to start the conversation, we have to understand that we are looking at federal, state, county, and municipal regulations. So where your condominium or a homeowner association is located in, or co-op, is critical. And you obviously have to understand all elements of those regulations, because, as long as they're not in conflict with one another, and I'm giving you a general comment here, for the most part, your local municipality can be more restrictive than your county, to the state, to the federal. So Craig made a very interesting comment about state of emergency. So as the governor of Florida has issued an extension onto the state of emergency for an additional 60 days, I believe that was May 8th, last Friday, he signed a new order in that regard. That obviously is the legislation that gives him the opportunity of putting forth these phase openings and things of that nature. So it's a very all-encompassing element. It has multiple impacts, but one of the impacts that it has, particularly to associations, is that it engages the emergency power provisions in the statutes for each one of your associations, which then gives you certain rights per each of those statutes to make certain decisions, controls the methodology of making those decisions, the meetings that need to take place, things of that nature, as well as what can be determined by your association as you are contemplating now balancing the closures with the reopening, which is an interesting challenge that we're all dealing with in the moment. So going to Craig's additional point is that we have counties which are starting to now show some signs of opening, processing, and conversation on that, which is now going to trickle to your local municipalities. And again, there's a varied reaction based on those municipalities which need to be looked at. I know some counties haven't logged in on everything. Some are still working through. I'm talking about the Dade, Broward, Palm Beach markets are coming out with different phases, and we're probably going to be seeing certain rollouts happening as we progress through the next couple days into next week, certainly in that regard. But obviously, for associations, what are we principally looking at, and what seems to be, the central core issue happens to be things along the lines of, your amenities, which I know is something we'll be talking about in a moment. Your management office possibly could be at issue, how we are dealing with visitors and contractors and guests on the property. I mean, these seem to be the kind of troublesome issues that we're dealing with right now, and the things that we need to be evaluating. So for the moment, my comment would be that we really need to start looking at a policy as you start planning into the next week or several weeks forward. These policies need to start being contemplated by your boards as you are progressing at this point. I want to add another just general comment that, in moving forward with this, there's another element of the law which has been a discussion piece, which is called the business judgment rule, which is a corporate concept, and it conceptually is making business decisions which are in the best nature or the best interests of your constituency in your case. And there's a certain degree of leverage that the corporate laws of the state of Florida provide to each one of your operating associations to make sound decisions through contemplation, principally at board meetings, as to how and what you should be doing. So, again, for your boards to understand, making decisions about, how we're handling opening up amenities, invoking CDC policies, which is critical to all of these. And I hope you all understand with each of these legislative pieces, there's a asterisk that, whatever you're doing has to be done in accordance to CDC guidelines. I think most understand that. So it's not like we can have a wide opening and we're going to bring everything back immediately to the moments we were in prior to this COVID crisis addressing our associations. But again, aside from the legislation coming out of the various condo, homeowner association, or co-op acts, we also have corporate rights that fall under essentially the business judgment rule to make sound, reasonable determinations based upon information that's available to us, as long as it's obviously in the best interest of our community. So another added, comment as to what your board should be thinking of as you're progressing through this.
Yeah, Gary, I have some questions later in the webinar regarding specifically, my liability as a board member, as an association, how I'm protected. So we will definitely talk about that. You did a great job kind of framing where we are and all of the regulations. I think what's important about this discussion today is we want to talk somewhat generally about a plan and what your plan would look like. You have to fit it into the municipal regulations. I think there's an overriding theory or fact that if the county mayor says the pool can open, it doesn't mean your pool has to open. It means it can open. So we're going to talk about a framework that you can apply to your association, which kind of details your plan. And we're advocating for communication. A big part of this is communication. Gary, you touched on emergency powers. We got some questions in our pre-registrations with respect to emergency powers. Can you outline specifically what those provide to the board? And then what are the limitations? Some things that boards sometimes think they can do, but the emergency powers don't give them the right to do.
Well, each of these statutes that address emergency powers have an outline of different things that the board can do and not do. So I'd rather not go item by item through them. All the things that we're doing right now, including scheduling meetings, if there's a need to schedule those meetings in a shortened time frame with shortened notification to the owners, was certainly a starting point. So from a procedural standpoint, they basically address those situations. They also address, in general form, the ability for boards of directors to make decisions about things like your common elements or common areas and the access and limitations to those things, as long as they're in the good and welfare of your community. They address things along the lines which are hopefully not things that are pressing right now, but financial raising of finances in the event that we need to go forward with a special assessment and or with a bank loan. Those types of things are available also. And again, what's the contemplation through that is that if you are in a emergency situation, that you are able to access those things and potentially not have to go through your documentary requirements for unit owner voting. One of the comments that I want to make in regard to emergency powers, including meetings right now, is I am generally of the opinion, and my firm is as well, that we are kind of in a different moment sitting here in the middle of May than we were sitting here in the middle of March, meaning we were really, not that we're so much more in the know now, but from the standpoint of where we are and what the legislation was going to be and invoking policies, which needed to be done fairly quickly, we were in a state several months ago to make quick decisions, and we really didn't have the opportunity of a 48-hour notice. There wasn't really platforms available, which again is something we'll be talking about by way of technological meetings that we're having right now, as compared to our traditional gatherings. Those types of things weren't available. So where we were in mid-March is I think we were really acting under those emergency powers from the standpoint of making decisions, invoking policies, and doing it in a quick manner, obviously to protect the best interest and welfare of our ownership and residents. So as we're now folding out, again, where we have to make those kinds of emergency decisions, I think those are available to us. But if we can put forth a 48-hour notice and we can put forth a Zoom meeting or some platform meeting like we're doing right now, it is highly encouraged to do that and not rely on the emergency powers if it's not necessary. And again, it's emergency powers pretty much based on the imminency of the issues. So, I mean, I know everybody wants to open up their gyms and their pools and things of that nature, and to some that may be deemed critical. But again, in the general state of affairs, I think we could establish the policies, put them into effect, have a board meeting to adopt that policy, and utilize one of these, computer-generated formats in order to do that. That would be highly recommended.
Well, Gary, that's a great lead into the reopening of amenities, which is going to form the bulk of our discussion, I think, this afternoon. Before we get to the specific use of amenities in the community, though, we did get a bunch of questions around just general common area things. And I have a couple of quick hits for you here. One question was, can we limit the number of people using the elevator at one time?
Well, what do you think, Craig? Can you?
I think you can. I mean, our view from Castle standpoint is, and what we understand is the board can adopt reasonable rules relative to the situation. And a reasonable rule would be, we can only have our elevator 6 by 6. We can only have 2 people in to maintain kind of social distancing and gathering. We don't want 10 people in an elevator. So my answer is yes, but I can get in a lot of trouble for giving advice. So I'd be curious as to what you think.
Well, look, I'm not an engineer to determine, what the statistical, placement of people are on an elevator of a certain size. But look, I will say as a general comment, as myself and my firm has moved through the past several months, there's an interesting balance between unit owners and residents wanting the available, common areas, common elements made accessible compared with those same residents who are looking out for their own safekeeping and welfare. It's an interesting balance, and it's something that I think each association needs to recognize, appreciate, and respect. So in that regard, not that I'm here to stand on a soapbox, but it's kind of like an answer to that question is certainly I think that if and they are, CDC guidelines are in place and we're supposed to respect a 6-foot distancing, we need to be doing something, I would say, by way of policy to address that. So if an elevator can only arguably handle 2 individuals, to respect that, then I think it's a reasonable expectation, just using your circumstance, to establish a rule of that effect. I think that an association may have more issue not addressing these issues, because I do think it's incumbent on a board, as one of its powers, as in any of the declarations that create our boards and our associations, that there be a consciousness of what is in the best interest of our community. And I think we need to adopt policies that are going to work. There have been some associations that just haven't been too interested in addressing for a variety of reasons. I think those associations have issue, because I think that really is necessary. It's part of the fiduciary duty of the boards for each of the associations to try to come up with reasonable policies that are going to protect the best interest of the community.
It's a great point. Across kind of the Castle Kingdom, we've been so impressed with the reaction of, residents to our team, largely the respect for rules, just because this is such an overwhelming pandemic, an overwhelming situation. On the back of the issue with respect to rules regarding the elevator, what about adopting a rule that requires residents or guests, to the extent you have guests, to wear masks in the common areas?
Look, again, I think all of those issues are CDC recommended and guidelines, as far as I'm understanding. They're certainly part of our government's discussions. I'm not talking about necessarily enforcement, but I certainly think that requesting at this stage, based upon the information that's been made available to all of us, that requiring masks to be worn when you are outside of your homes, requiring social distancing to be respected, are things that are the basis of everything that we're doing. So, for example, if your gym, which may be, a smaller gym, and we have treadmills right next to each other and things of that nature, I think, just using that as an example, I think that a board, along with management and potentially lawyers, have to come up with a policy that's going to work. Just using that as an example. Pool decks, the same thing. Your own particular designs of your own property are going to be very important to understand as you're moving forward with your policies that you're creating. So, I have one really terrific association that I have the privilege of representing in Lauderdale. It's not a very heavily occupied building right now, but they happen to have a lot of, gym rats that live in the building that love to work out. And the fact that the gym has been closed this entire time has been a major issue for them. So the community is very much looking forward to opening up the gym, but they also recognize that although it's an extremely well-equipped gym, it doesn't have a lot of floor space. So what they've done, for example, is they're now contemplating their opening with a reservation-only type situation, restricting on a per unit basis, per hour, access to the gym. So you have to sign up, and there's after the family, again, it's on a per unit basis to parts. The building will be sending in their janitorial folks to clean up and do what they need to do and make it available and ready for the next people to come in. So, I mean, again, it's all what works for your particular property. Obviously, a community that's higher in occupancies, that's not going to work. So, cordoning off certain equipment, so you're forcing social distancing to be recognized, and limiting the amount of people in this space, and obviously a higher degree of cleaning and sterilization. I mean, all these things taken together are part of these policies. Again, management's been fantastic figuring these things out, but these are the kinds of policies that you guys are evaluating and need to take into consideration.
Gary, it's a good point, and that's kind of what we're advocating. Listen, every association is so different and so unique. One plan doesn't work for everybody. So what we've done at Castle is we have a playbook. We've developed a playbook for bringing amenities back online. We did the same thing as we were shutting down communities, but now we've got kind of the reopening of the time frame. So what we wanted to do was develop a framework that an association, kind of an action plan for an association that takes into consideration the different regulations of the municipality they're in, their physical plant limitations, and you talked about the gym, the demographics of their community. That we have 55 better communities up in Palm Beach County who haven't, despite the fact they can open their pools, haven't, because they were 55 and better 25 years ago. So now they have an aging population and they're worried. We talked about staff. Another item to consider is staffing. In Palm Beach, I believe you have to monitor your pools. Are there sufficient staff to do that? And then finally, are there any budget considerations? So we have a playbook that we've defined, and I want to kind of take you through what we take our boards through. By the way, we're happy to make the playbook available to anybody who's listening. You can just email us at info@castlegroup.com and we'll send it out. But again, it's important for each association to have a plan, have a phased plan, acknowledging that eventually the clubhouse will be open, the craft room will be open, the bar will be open. So it has to be kind of a phased approach. So Gary, what we've done with our boards is we've sat down and say, okay, please consider what are the current regulations affecting my community, state, county, municipal, and then what an overriding factor is, what are the recommendations of the CDC, specifically with respect to social distancing and gathering. Those are the goalposts, if you will, that you have to fit your plan under. Then we're going through a process that says, okay, what amenities do I have? I have pool, I have tennis, I have bocce, I have a gym, I have card rooms, I have a craft room. So you need a plan for each one, and again, with these overriding goalposts, do the regulations allow me to open the amenities? Different rules by county. What are the restrictions that affect them? I can open my pool, can't have chairs, or I have to monitor it. Then we've said, okay, what are the demographics of your community? If you're 55 and better, I talked about that. If you've got a bunch of gym rats in the building and you have a small gym, what does that look like? Does the setup of my amenity provide any limitations on reopening and complying with the CDC guidelines? So if you have a small gym and we've all been in gyms, and I like to walk by them rather than go in them, but we've all looked in a gym and you can see the treadmills lined up beside each other. Well, can I practice social distancing if I'm standing beside someone who's shoulder to shoulder with me, on a treadmill? No. So do you have to rope off one of the treadmills? Do you have to move equipment around? These are all considerations depending. And then we have other gyms, by the way, that are completely spread out and you don't have to do anything. The other thing we talk about is, do I have staffing limitations relative to the opening of my amenities? Cleaning protocols is a huge change I think, in terms of, cleaning after each use. So I love your plan, and we're seeing lots of plans, Gary, around, scheduling 1 hour sessions in the gym. If it's got a capacity for 24 people, maybe you allow 6 in, from 9 to 10. At 10, you shut it down and you clean it for 15 minutes. 10:15 is the next slot. So these are all considerations that our boards have to go through. And again, we suggest to them, have a plan. We have a saying at Castle, don't let the perfect get in the way of the good. And what that means is you're going to start with a plan and it will likely change. But we're saying have a plan, communicate it, implement it, monitor the changes in regulation. So it's going to change as the rules change, and then, adjust it and re-implement, if you will.
Just to add, Craig, to your great points, just a couple comments. So listen, again, I'm only speaking of what I'm experiencing with my great clients, some of the issues and troubles that they're engaged in and trying to figure out. So to add to your point, though, one of the things that need to be contemplated in these plans and policies are resources. Mm-hmm. And I know you captured it in some specifics, but I'm going a little bit broader. But, if you cannot implement some of these well-thought plans because you're limited in resources, and resources could be, again, staffing, it could be actual chemicals, materials. I mean, these things are not necessarily open and available on the market. I know some associations are already starting, there's a supply chain type of situation, as we've all experienced on a personal level. That is also happening on a commercial level. So I'm sure Castle's on top of much of that and is, working through with its muscle to make as much available to its associations as possible. But there's a reality there that there may not be, all the proper, cleaning materials and gel stations and wipes that may be needed in order to exercise some of these powers and policies. So that's something we really need to take into consideration and figure out in the policy making. And if you can't, it may affect your policy. So putting out a policy that you can't put forth is, and execute is really not going to be very helpful.
Right.
Second point I wanted to make is also with regard to finances. I mean, I've had several associations come up, and it's using, I'm not going to try to quote you in your Castle philosophy, what was really good, but conceptually, they come up with a really good plan, but then when we put it into the form of application, it turns out we don't have the financial resources to pay for that additional janitorial person, as well as the additional cleaning materials and whatever it is. So my general comment, now going as a lawyer here, we don't want to create a liability for ourselves. So the fact that we may not be able to afford it, we now have to address, can we afford it through other means? Is there conceptually a special assessment that we need to put forth in order to keep our facilities operating? I know it's a difficult and dangerous word sometimes, or term sometimes to apply, but it is important to talk about. And if we can't, under the worst case scenario, it can't be generated, those funds, I'm of the opinion, and again, it shouldn't be happening, but in those kind of extreme circumstances, we may not be able to start reopening things if you can't apply CDC guidelines. I mean, that has come up before. We don't have a security person on the property. We don't have janitorial. It's not designed. We don't do it that way. So how are we going to clean? We're not going to certainly ask the manager to go clean. That's not within their scope, certainly. So how do we do that? And my answer back to them is, if you don't have the ability to do it, you need to reconsider opening up your facilities. They come together. So if you're going to do it, you have to have a plan to execute, which is the last thing I just wanted to point on, which we haven't talked about, but it is a very important element, is enforcement. Mm-hmm. And, we are not a police force. We don't have, when we talk about masks and social distancing, and, we haven't spoken about the scenario of, what happens when we have determined through communication that there's somebody who is COVID positive on the property, and what additional processes we've put into place, which I'm sure most of the Castle properties have done in that event. I know the ones that I deal with certainly have, as a result of management's recommendations and intuition. They've put these things in place already. So, how do you enforce is an issue, and it's something we need to discuss very briefly. Again, it's a challenge, but it's something management and then onto the attorney may have to be dealing with through enforcement letters, through conversations, through, again, I put those out of sequence. I would certainly start with conversations and communications on property management, starting, if necessary, some form of written communication, and then moving into, in the worst case scenario, engaging the lawyer for enforcement letters, cease and desist letters, things of that nature. I mean, it's unfortunate, but there's a reality that, people obviously have different ways, and I'm sure we've all experienced it, have different ways of interpreting what we should or shouldn't be doing in different senses about that. But obviously what comes back to the association is being able to implement these policies that we put in place. So putting them in place without having any ability to do some level of enforcement is something that needs to be evaluated. How do we enforce these things as things progress? And again, last comment, we're not a police force.
Yeah.
So there's only so much that we're going to be able to do within the rights that we have. And fortunately, I haven't been involved with my clients having to file any kind of litigation or anything like that to enforce, but it has gotten, unfortunately, problematic in a few situations where, somebody, for example, who's COVID positive, the spouse of that person is seen all over the property and isn't doing any type of quarantining. And, the association has had to really come down on that person to ensure that they're not, infecting or challenging the welfare of the fellow residents of the property. So these things are things that need to be contemplated.
Absolutely. I think a couple of comments I would make, and it's a bit of a commercial for attorneys, but we are certainly advocating that if you are developing a plan, run it by your attorney. Make sure, you dot the I's and cross the T's. And we're going to talk about liability after, and that will serve you very well when you're standing up in a courtroom trying to defend the actions that you've taken. The other thing I would say, with respect to the opening of amenities and the resources, when you're allowed to open the pool and you decide to open the pool, it doesn't mean it has to be dusk to dawn 7 days a week like it was pre-pandemic. You can limit the hours. We have an association that has done a wonderful job. They've created 4 blocks of 90 minutes. They've determined they can have 50 people at the pool. They've sanctioned off the pool area, and you sign up, and then 90 minutes goes by, everybody goes home, they clean for half an hour, and they go in the next 90 minutes. So there are ways to work around this within the guideposts that I talked about and you talked about, the CDC guidelines. The other thing I would say is a tool for enforcement. We had one association up in Palm Beach County. They opened their pool. They just couldn't control the residents, so they shut the pool. Like sometimes it's that simple. It doesn't have to be a sophisticated response. The other guidance we are often giving our associations, and I know you are as well, is if you listen to the vocal minority in your community, you may never win. So there are unpopular decisions to make, but most people understand the circumstance of that.
Yeah, I mean, this may be a little bit of a dangerous analogy or analysis, I should say, but I have found that in the comparison, and Craig, you and I have spoken about this in the analysis over the past 2 months. And again, I'm just saying this to kind of maybe assist some of the boards in their thinking through of these policies. I think we've been certainly getting more concerning communications from people concerned about the welfare as we are in comparison to those people that are seeking the reopening. So again, to the point, I think people are much more vocal and much more clear about their concerns about safety and security. Those people have been much more clear about their positions than those people who are upset that the gym has been closed or the pool deck has been closed. So what I guess the general takeaway from that is, and again, I'm maybe going outside of my realm as a lawyer, maybe just try to give a little assistance there, is that people are very, very concerned. And I think that's not going to change about the establishment of policies that are ultimately for the good and welfare of the property, taking into consideration that allowing people access is important, but it has to be done the right way. So using Craig's great example of, of a gym or a pool particularly opening with restricted hours, because that's what the resources that the property has allows, is really smart and is within your realm. There does not need to be a wide scale reopening if your property can't handle it for whatever reasons. So these are all things that need to be taken into consideration as you're moving forward.
Excellent. So again, I think the answer is, have a plan, look at your community, look at your municipal regulations and your demographic, and then, kind of come up with a plan that you communicate. Gary, I want to move from that on to meetings. With a number of questions around meetings, our amenities are closed. We can't get in our clubhouse. We're practicing social distancing. We're respecting gathering rules, but we want to have a meeting. Can and should we be having board meetings?
So the answer is yes. And again, at this stage of evolution, which has been a short window, but 2 months, we have all, meaning management and this particular law firm, have all gotten very accustomed to this format. Not this necessarily absolutely this format, but a digital type format for meetings. We've handled board meetings, we've handled unit owner meetings, we've handled annual meetings in this manner. Last evening, Castle, just coincidentally, one of your properties, of which I have the good fortune of representing, we had a annual meeting and election of directors. It went relatively smoothly. We had some very, very good management that you guys provided, that were willing to be present on the property to conduct the physical elements of that meeting. And they deserve a lot of credit, obviously, for putting themselves forth in that regard. So kudos to the management team last evening and well-serving Castle in that regard. But yeah, it was done. The board was seated, and organizational meeting took place, and owners had the opportunity of participating. In that case, it was done on a webinar format. So that participation came in the form of written questions similar to this one. But I believe it was administered in accordance to the statutes, and that people had the opportunity of speaking on each agenda item, speaking relative, meaning they had the right to communicate on each agenda item. And that's how that meeting was conducted. So in that regard, what I would only say to you, and I would rely heavily on management to assist, is that there are different formats for these meetings. And based upon the nature of the meeting, the amount of people anticipated to be on the meeting, there are better formats for each one of those search situations that you need to understand. So, open mics are difficult to have just because, not that we don't want to have it, it just seems to be, we have everybody's background noises. This one has a air conditioning unit that pops on, barking dogs, things of that nature. And it just makes it very difficult to conduct a meeting under those situations. And then you have people talking over each other, which is going to happen. So, we have to figure out the best way to do it. And again, in a meeting sort of like the one we're having right now, where there's muted functions and there's ability to either raise hands or write in your questions, I believe under the circumstances, they all work within the statute, in my opinion. So just to add one other comment to that is, again, as you're moving forward with establishing these new policies, and you've already adopted former policies, again, it is my strong recommendation that even if they were done on an emergency basis, meaning within a 48-hour time frame, all of those policies should be presented at a 48-hour notice meeting for ratification, which would be the proper term to be used under those circumstances. And as we're moving forward to adopting new policies to kind of like reintroduce the property, open up the property again, it would be my recommendation, if possible, to do those also in a 48-hour notice meeting. Comma, you can use a special board meeting agenda, which is not a regular typical board meeting where you're doing all your minutes and having your reports and things of that nature. It's restricted to several items for the board's consideration. So again, I highly recommend it at this stage that once we're readopting or adopting new policies, that we do it through a board of directors meeting.
I think, Gary, we are setting up a ton of meetings. I think certainly I did, and I don't think our team ever realized how effective a remote Zoom style meeting can be. The fact of the matter is we're seeing more participation from unit owners, which is a great thing. And it's an opportunity for the board to, communicate the plan to the association, which is equally as important, I think, at this stage. The other thing I would say with respect to, Zoom's kind of the new technology, we're getting a lot of people now signing up for some electronic voting is kind of progressing quickly. The whole concept of using technology tools, getting your correspondence electronically, it's really been eye-opening. I think it was inevitable, but certainly this pandemic has accelerated some of those tools.
Agreed.
So have meetings, communicate the meetings, and you can dot all the I's and cross all the T's with respect to the, your legal protection for doing that. Gary, let's move on to what's next. We have 10 more minutes and a couple more topics and then some questions. We're starting to see the state of emergency declaration may expire July 8th. Municipalities are starting to, undo the restrictions on amenities. I think it's just a matter of time, as I said earlier, with respect to clubhouses and things coming online. I know in Miami-Dade, I believe gyms aren't open yet, but in Broward they are. So it's just a matter of time before Miami-Dade opens its gyms, I think. Gyms in Broward within associations. I don't think we're going back to the old way for a while. We're suggesting there's a new normal, but we are going to come out of this, and when the dust settles, we're going to have lawsuits just because of the nature of living in Florida. Residents feel they've been wrong because we closed the amenities too soon. We opened them too fast. They didn't like a rule we adopted. I want to just get you to give our webinar participants, kind of who are directors and officers, just what protections are afforded them by, the state, the governing documents, and then maybe insurance as well.
Well, again, I stated some of these before, but to your good question, I'll kind of capsulize them to the one you just raised. And that is, again, strongly recommend that the policies be adopted or contemplated, obviously with reasonability in mind, based upon your property, based upon your municipalities. You can be, to Craig's earlier point, a bit more restrictive than even your local municipalities. You can't necessarily conflict with them, but in some situations you may not even adopt, because of some of these conditions, you may not be adopting all of those policies. So for example, if you don't have an ability to adopt a policy for cleaning, like we discussed, in accordance to CDC guidelines, you need to reconsider, can you open up your pool deck, things of that nature. So, but putting that aside, I'm going back to discussing with your attorney as these policies are coming up. Do they fit within these emergency powers that exist in across the board in all associations in the state of Florida right now? Do they match with your municipal, state, county requirements? And again, do it in accordance to board meetings and have your motions, have your debate and discussion so it's clear, which all works towards the reasonability factor, the giving of the ownership, the opportunity of weighing in on some of these things. And then that kind of establishes, once again, going back to my comment about business judgment rule, that kind of plays into that decision making. Again, I can't tell you that you're going to be liability proof, but if you go through some of those critical steps and stages, I think you're going to be in a much more comfortable position and minimize liability by going through those steps. I think probably, and Craig, you may agree, where I think you're going to probably be seeing, repeating myself, I'm sorry, but some more litigation, maybe more in the lines of, a lot of associations have discontinued contractors going back to essential versus non-essential coming onto the property, and some potential damages that a unit owner may have incurred either in the context of the construction contracts, possibly with regard to the merchantability or sale of the unit, things of that nature. Again, as we are using the term opening up again, you need to be conscious of those types of things. So a quick example, I mean, having a contemplation about move in and move out, and not maybe doing it the exact same way, but creating a new policy, maybe using a different elevator, a different loading area, having mandated that, janitorial has to be available during the entire span of the move in, move out to keep, the hallways and the elevators sanitized in the event that elevator is going to be utilized by other people during that time period. Those types of considerations are things I think we need to start discussing. And so it's not an absolute no. In some cases, it may remain an absolute no. I just had a call the other day, in contemplation of this in the Palm Beach Association, where a unit owner, let the office know that 7 family members were coming down from New York by car, and they're staying in the building. And, there was great concern. They don't have that building resources. They don't have large janitorial ability to keep the building at a higher sanitization and things of that nature. So we had to have that conversation if that was going to be permitted. In that case, the board of directors made a decision that that was not going to be allowed. And I think they were within their right to do it. How they contemplated and evaluated it, and under the basis of how they determined that they were not going to allow that level of guests onto the property. They didn't have the resources to handle that load. So again, going back to the question, there will be potentially some liability coming out of this. I think if you go through the steps of evaluation, of having the meeting, of having the discussion, weighing in potentially with your legal counsel. Again, you weren't going for an ad for legal. I'm gonna not do that either, but it may sound that way. These are the times when your lawyers are very effective. And again, we are in uncharted waters right now. So relying on the advice of your attorneys and relying on the advice of your management is really very important at this stage. So we want to try to minimize your liability, but your attorneys can't do that if they're not brought into the discussion. So now would be a really good time. Again, not advertising that everybody should be running to their lawyer for every issue, but these are issues that I think are very valid and really need legal contemplation.
I agree. I couldn't agree more. One of the things we had some questions about loosening the reins on allowing family into communities, with respect to when we were shutting down, boards did a lot of restricting of access. Started with, not gathering 50 people together, quickly went to 10. Boards started allowing what you call non-essential visitors, which I love that term, right? Not, the housekeeper who's not required from a health standpoint to get into a unit, work in units. I have to tell you, across our kingdom, we haven't seen a lot of relaxing of those rules yet with respect to non-essential visitors. What are you seeing, and what are your clients asking you?
I agree. Again, where I think we're seeing a little bit more is, the ownership who have been patient through this course are now looking towards this in a more long-term focus. So, I was okay with not putting in my tile that I was planning on changing in, April 15th when I was going to start the project. But you know what? I really got to get my tile replaced. I'm just using that as an example. And, I can't put that off forever. I bought the tile, et cetera. I'm under contract. Again, so thinking through the resources of your property, the ability to actually access in a more healthy environment, requiring potentially an expense to be borne by the unit owner for, additional housekeeping and janitorial because of that. These are all things that I think need to start coming into the psyche of the board. I'm not saying right now, again, in the example I gave you, we probably are not in anywhere close to a position to start opening up our buildings again to the poker games on Wednesday night and the events happening in our public spaces and things like that. I know of no building that I represent who has said at this stage that we're planning on opening up all of our public facilities.
Right.
Period. Everything has been evaluated under CDC restrictions and what really needs to be opened up in accordance to, local potential, most probably local direction.
Gary, let me ask you a quick question, probably the last one before I do a summary, but we got some questions around collections. At Castle, we're kind of advocating for collections as normal, of course, understanding that some people would have been more affected financially by this, by this situation, and to approach the board if you are, but what are you telling your clients?
Well, as an early stage to all of this, again, thinking down the line a bit, one of the recommendations I've made, and I know Castle has as well, is I would start by saying, and I'm not trying to be negative in this regard, but I just think it's a good thing, is that I think there needs to be a conversation with your banking institution as a starting point, just to understand, what financial options are available by way of lines of credits and things of that nature, just to put them in some form of order. So whether you want to actually proceed just to have things, I know some lenders are doing that with nominal expense to the association, just so you have a bit of a cushion. It may not be a bad idea to have those conversations. But again, there's no legislation that's currently been put into place that is really preventing moving forward with association assessments and things of that nature, as compared to mortgage foreclosures and evictions and things of that nature. But again, associations need to understand what they have the right to do. So I've gotten multiple calls in contemplation of this. It seems, and again, you have better data in this than I do, Craig, on behalf of Castle, but it seems that for the moment, meaning the April and May periods, we're not seeing a huge change in delinquencies. A lot of the associations I represent anticipated April to be relatively stable, but we're concerned more about May. But as I've spoken through to them and we're past the first 10 days of May, that typical grace period, most associations aren't seeing any huge effects from what I've understood. But if you are contemplating, how do we react? Associations are looking predominantly at late fees, at interest as being a source of possibly some level of negotiated platform. Assessments are not. I mean, that's not a right. We can't waive people's assessments. That's how all your entire community operates off those assessments coming in monthly. So that's not an option. But interest and late fees may be. And again, my comment would ultimately be, handle these matters on a case-by-case basis. Contact your attorney if there is a situation that the board feels is extraordinary. Payment plans, things of that nature, are things that you may want to consider. They should be a nominal expense to the association to put on paper with the association's attorney. And we have to work on some of these matters. Are going to have to be worked on a case-by-case basis.
Yeah. Gary, I think that's great guidance and similar to what we're doing. By the way, we've seen really no material increase in delinquent balances across our associations right now. So that's the good news. I'm not sure the effect of all of the unemployment and stuff has rolled through the economy completely yet, but we're happy about that. With respect to cash flow, ultimately, if you don't collect, that's what creates your cash flow problem. What we've talked to our clients about is, let's sit, we've had lots of discussions with our treasurers, sit back, let's kind of do an inventory of where we are. Do we have surplus funds we can use? Do we go get a line of credit, which a lot of lenders are doing right now? We're processing a lot of kind of emergency line of credits. I don't want to get into the utilization of reserves for operating purposes. Talk to your attorney, talk to your management company. There are tools in that regard. Gary, I'm going to wind up. We're about 5 minutes over, but I wanted to do two things. Thank you very much. Always a pleasure. Nice to catch up with you.
Thank you.
Who participated. We talked about the regulatory environment. I think Gary's advice was it's very locally driven. So it really depends on where you are, but let's look to that guidance before you do anything with respect to your amenities. Talked about a little bit about emergency powers, a lot about the reopening amenities, and I think we're advocating for, we have a framework, design a plan within that framework that takes into consideration, the nuances of your association. Have meetings. We talked about that, and keep your head up when it comes to opening these things up. Have a plan, review it with your attorney, protect yourselves from a liability standpoint. So, Gary, thank you very much again. I want to remind everybody, we will get to your questions if you ask them and we didn't address specifically. I want to remind everybody, May is Mental Health Awareness Month. At Castle on Monday, we're wearing green for mental health, so it's a big issue, and I'm sure it's been exacerbated by the pandemic and everybody being locked at home. If you want a copy of our playbook, email info@castlegroup.com. We'll make sure that gets out to you. With that, I will say thank you to all of our participants this afternoon. Have a wonderful weekend. Stay safe and healthy. Gary, thank you.
Thank you, Craig.
Take care, everybody.